There's a few things to address, Your Honor. There is a bond violation currently right now, and we of course want to address that. I believe it occurred on the 19th of January, her being, I think, either 14 or 17 minutes late against the curfew. And so when I spoke with my client on this, she explained it as far as what the situation was. This was the Friday right before the big snow, and everyone was going crazy. Of course, we all anticipated like it was going to be the last freeze. So she went to the store to be able to get supplies and load up on all of the necessaries, as everyone felt they should. And of course, the stores are crowded. Traffic is everywhere. Prior to going to the store, my client took her 3-year-old daughter to her 70-year-old aunt's house. And the reason being is because, one, her daughter is special needs and she just does not do well in a social setting. And recognizing that it was just craziness, she had to take her there first. Lines along, everything, once she leaves the store, it's apparent that, she very well may not be able to make curfew, but she did have to go get her daughter.
So we only have the one violation at 7:15.
That's correct.
Is that it?
That's it.
Okay. Come up, Mr. Treadwell. Ma'am, it's not the end of the world. I get it. But bond conditions are bond conditions, and you have 2 open DWIs, and you must understand that you and I are operating under strict compliance. I will give you a pass now. It's not going to happen again, though. Do you understand? Okay. All right, counsel. You're good to go.
Other matter, Your Honor, we did also want to approach on the court's consideration, or more so reconsideration, of the recommendation for inpatient treatment. Now, we visited this previously.
Correct. And every time I deviate from said thing, we end up regretting it.
And
10 times over. So
you shared that with us last time. I do understand that. I at least want to do my client a little justice and at least give him some reasoning behind why we believe outpatient would be a little more appropriate. So the first thing is, my client, she has been sober for 103 days. She has exercised diligently and staying committed to sobriety. While she has been released, she has been regularly attending AA meetings, meeting with substance abuse counselor who just had a home visit with her a few days ago. She has obtained her health insurance, which was previously lost due to the loss in employment, but now she can further recovery by taking advantage of the psychiatric care, therapy, and whatnot. And 2, and this is really primary, the family circumstances. The circumstances of the family are the type that requires my client's presence at home. She is the caregiver primary caregiver of 2 daughters, ages 10 and 3. The 3-year-old, as we shared before, is a special needs child. And when she was in custody after the second offense, it was her parents who did take care of the children.
So luckily we have that going.
Well, yeah.
Have someone to watch the kids.
Yeah, and that was for just about 30 days or so. Definitely operated as a hardship as the parents. And of course, in these kind of situations, there's going to be sacrifices. Sacrifices has to be made by all parties. But we're talking about now 180 days, 6 times that amount, which, again, I think it would be a tremendous hardship. And particularly with, I think a lot could be said about it, but particularly with the special needs child, what we do know about that demographic is they need routine. Routine is keen in their lives. If that is removed, it's, they could get discombobulated and it could operate as a crisis to them. So what we do know is if she does have to go to this outpatient program, home is no longer going to be there. They're going to have to move with whomever.
You say she doesn't have health insurance?
Oh, she does. She does now. She obtained it as of July 31st. July 31st, right? Yes. I'm sorry, January 31st. Excuse me. But yeah, so they would have to move. They would have to switch schools. just uprooted from the life that these girls do know and understand. And again, particularly with the special needs one, possibly not even be able to attend. Is it occupational therapy? Occupational and speech therapy. Thirdly, Your Honor, when early on in this case, I had acknowledged, I had informed the court of my client. She is prescribed Adderall, and at the time of the offense, during the time of these offenses, her therapist had, they were adjusting her meds, even had her on an extremely high dose of Adderall. And I don't want to portray myself as an expert in this at all, because I just found this information out, and that is that Adderall with alcohol, of course, that's a bad idea already. Okay, but what it does on a molecular level, they're both fighting for enzymes, and the enzymes are what's extracting it, getting it out of the body. The effect is that they mask each other, and so someone that is drinking while on Adderall, they're not feeling the effects. They're drinking and drinking. Your body is not telling you, okay, hey, we're intoxicated, but all the while, of course, the blood alcohol levels are through the roof, even to a fatal level in some instances. The blood alcohol levels here they're up there.
How high are we talking?
Hi, Your Honor.
Yes, Judge.
Yeah, no, and I understand, and that is
You realize that most people at that level, 0.4 is dead.
That's right.
Right? You're at a 0.4, you're dead. At a normal person at 0.3, they'd be passed out 3 times over, right? It's to be able to get to that level at a 0.3 and then a 0.2 on that truly tells me that there is an issue there.
Oh, absolutely.
Right? And me, with that kind of levels, right? And we have 2 open DWIs. If I don't follow the recommendation, because that's why we have these people. They're clinicians. They're experts in what they do. They make the evaluation. They make the choices. I understand it will create a hardship, but sometimes that's what needs to happen to gain perspective and to gain knowledge. I understand your plight. I understand your position. Every time I deviate, you regret. She has a 0.3 and a 0.2. What was it? 2.8. A 0.28 and a 0.3 on 2 different DWIs.
That's correct, Your Honor.
I'm sorry.
Well, and again, I know that
I understand.
That is
I'm never going to be
attributed
a lawyer for, zealously advocating, and I appreciate it. And, you have to do what you have to do. I understand. Sorry. It's too much. If it was a 0.4 or a 0.14, but we have a 0.3 and then we have a 0.28. Really, it's too much. I don't know how you want to move forward, but I am sorry. I don't want to deviate from it. We can give you time to make arrangements, but I think that that's the appropriate course of action. I'm sorry, Ms. Treadwell, because there are consequences to actions, right? And I know that it's going to be hard, but I think it's going to be all for the better.
Your Honor, I absolutely agree that when we're talking about treatment, who could speak against that, and I do understand that.
And we're giving it to you for free. You get out there, you're going to have to pay for it on your own. You're going to end up thousands and thousands of dollars to pay for it. I can't pay for treatment on the outside. I'm telling you, I know that you have insurance. Insurance is only going to cover a portion. When you go to these outpatient treatment programs, they're thousands of dollars.
There is also the KEYS program and the Access program that,
she's a 0.31 and a 0.28. Really, that needs a lot. That's why they recommended it. And I'm sorry, but I wish I could make a different decision, but sometimes we have to make tough decisions as well, and I'm sorry, Ms. Treadwell, but I will give you as much time as you need to make arrangements, but I truly think that that's the best and appropriate course of action. Okay.
How much time?
I mean, your first case is, your second case is 104 days. The first case is 153 days. So you've got some time, but I mean, we're running up against it. You know, I'll give you another 30-day setting, but that's it.
Your Honor, would we bid in 45 days? Because there's gonna have to be some major movement that is done on her end, to even try to get someone and make arrangements for the
I will give
children.
it to you, but that's it. I mean, really,
No, I get it.
at the next setting, it's player trial. I'm not going to play this game. I will give you the 45 days, but everything needs to be done by that time. Okay?
Yeah.
All right. Sorry, sir.
The field sobriety tests and the odor of alcohol still gave the officer enough for probable cause. Not guilt, just enough to move forward. Would you trust the officer's judgment here, or should the breath test alone decide everything?
Please. Mr. Perez, you're charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. So, correct me if I'm wrong, but he was out on bond on this case, right?
Judge, I'm not.
Yeah,
Not
we
sure about
gave him a
that.
general bond and he failed to appear. You know, Mr. Perez, we gave you a free bond and you got out there. All you had to do was come back, and when you come back, good things happen. I want you to listen. Your failure to appear, we issued a warrant, we revoked the bond, you ended up going back to jail, and you spent enough time to where immigration was able to put a detainer on you. That's why you were stuck in there now. For future reference, when you pick up a criminal case, come to court because good things happen. Had you come back, it probably could have been resolved in a good way for you. Do you understand?
Yes.
You also need to understand that what you're doing now is you are pleading guilty to the offense of driving while intoxicated.
We're actually putting on probable cause.
Oh, you are? Oh, I thought you were pleading to.
Judge.
Oh, my fault.
Well,
Well, it may end up good. I don't know.
Actually, once he was detained, he was taken to immigration almost immediately.
Oh, really?
The GOP bond, Judge.
Okay. I thought he got out. You sent to immigration?
Yes, he was denied bond and he was
Got
returned.
it. Okay, well, he got a bond, I guess, because of the GOB,
Correct.
so you don't think there's PC?
I don't think there's probable cause in this case, Judge.
Do it up.
Yes, Judge. On December 16th, 2024, at approximately 12 a.m., the officers were stationary on West San Houston Parkway when a prohibited vehicle alert displayed a gray Mustang that was prohibited on the toll road. The officer observed that the vehicle was prohibited since August 25th, 2024, and owed $1,536 to the Harris County Toll Road Authority. The officer initiated a traffic stop. Upon contact with the defendant, who was the driver of the vehicle, the officer observed a strong odor of an alcoholic beverage, red glossy eyes, and slurred speech. The officer observed the vehicle to be registered to the defendant, and the defendant admitted to drinking. Stanfield sobrieties were conducted, HGN 6 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The DIC was read and the defendant considered a breath. The results were .067 and .065. And the officer further stated that the defendant's BAC would have been .085 at the time of stop. And that was whatever that, yeah.
Okay. What's your argument?
So my concern is that it seems like the police officer has some type of suspicion that he was intoxicated, asked him to do this FST.
No.
Yes,
The
Judge.
stop was initially because it's a prohibited vehicle, right? You owe a crap load of fines and fees to the toll road. You're not supposed to be on the toll road, right?
Right. But I mean, in regards to DWI, Judge, I mean, he asked him to do SFSTs, he conducted those, and he doubled down on his suspicion and asked him to do the breathalyzer. An hour and a half later, he blows under the legal limit, .065. That's significantly less. Now, it's the cop's suspicion. Now, at that point, he uses speculative reasoning to believe that it was a .08 at the time that he was driving without any type of scientific method or any type of legal or actual scientific basis.
Remember, this is probable cause. we can't get into the facts to whether he's guilty or not guilty, whether he's really at a .08 at the time of driving. I don't know, but that's why we have trials, to give them the opportunity to respond to what your argument is, because they can't possibly do it now, you know?
I guess my concern is that if you look at the circumstances in totality, I mean, it seems like if the police officer was doubling down on his suspicion, asking to do a breathalyzer, and he passed it, at that point, the other exams were basically just a physical test instead of actually a test for intoxication.
And you may be well right as far as beyond a reasonable doubt. But this is just a probable cause to see if we go forward. Set the case for trial. I think, you know, it would be a great trial.
In that case, Judge, we would ask for the earliest trial.
Yeah, but here we have a good stop,
Yes, Judge.
smell alcohol.
Yes, Judge. Then glossy eyes, and then also, I apologize, let me pull up, and slurred speech. And then after
We've got
that,
all the indicia to begin the DWI investigation, right? Did they do any SFSTs?
after that, they did SFSTs, and they had 6 out of 6 HGNs, 4 out of 8 walking, turning, 3 out of 4 one-leg stand.
Right. So I think that there's enough just to go forward for probable cause purposes. Now, set it, you know, you may be right as far as they may, you know, it's good for probable cause, but it may not be enough for beyond a reasonable doubt.
Sounds good.
I have to give them at least, we got to give them, what, 30 days? So we can set up a trial in 30 days. Be ready, watch the videos just to make sure, you know, it coincides and.
Just to understand, I have to wait 30 days to set it, or I
No,
can?
no, no.
No,
No, let them know now so that they can get their ducks in a row as far as subpoenas and all that, you know, and is the breath, is what discovery's in.
Yes, and it's completed, yes, you have. We're just missing station video, but everything else.
Okay, that's a big part, you know, because you're gonna need that as far as breath testing and stuff. So, I mean, just stay on top of it. If you want to set it now,
Yes,
you
Judge.
can. If you want us to get a couple of weeks just to see if you can get the video,
I think
whatever you want to do.
Judge.
Okay, just let Victoria know.
Thanks, Judge. Have a good one.
Hi.
The field sobriety tests and the odor of alcohol still gave the officer enough for probable cause. Not guilt, just enough to move forward. Would you trust the officer's judgment here, or should the breath test alone decide everything?
Good morning, Mr.
I
Lee.
have Mr. Khalifa. He is in custody. And
Okay, right?
yes, with the K.
How is Mr. Khalifa?
He is, you know,
Like him. It's just,
he is very adamant. Say that.
yeah,
So
it's an understatement, right?
his felony attorney, I actually know his attorney that's on his felony, and he was here this morning. And I was talking to the chief, and you know, at this point, it would be time to set these for trial.
Okay,
And
it's up to you.
the
I mean,
asking for 2 weeks to talk to felony to see if they want to dismiss it. But if it does go to trial, I'll need an Arabic interpreter to review evidence, and I think also.
are there videos? Hold on a second. Whoa. Have you looked at the discovery?
Yes.
Is there stuff in Arabic?
Yes, Judge, there's text messages.
Okay, so you got to go get all that stuff. That's a, hey, they're saying some of the videos are in Arabic.
For the text.
The text
So-
messages.
The prosecutor.
Remember, we need at least 45 days just to translate that video into Arabic.
Right.
So get on it now. Are you going to go to trial on this thing?
If they don't dismiss it, I am.
Okay, so can you send it to you need to transcribe it in Arabic. That takes at least 45 days.
Right, and we just have 188 in one entire office that speaks Arabic, and he has his own document.
No, but they send it out. But you got to put in the order now,
Yes, sir.
if you don't mind, please. Okay, so,
If they don't dismiss it, we have no reason not to. go to
yes,
trial.
hey, look,
Right.
but I'm saying, let's get the order in now.
Exactly.
Because it takes 45 days. That's why.
Well, they may dismiss, but. I don't know.
And May is a big, you know,
I understand.
I want to make sure that gets done so he doesn't languish in custody because
Exactly.
we can't go to trial until that video's
Well, no
transcribed.
bonded on his felony, and that trial date's October 9th.
Of next year.
Well, this year now, 2025. Yeah.
They set a trial for October of this year?
And he has no bond in the 179th. So.
I have a trial in October, so go on felony. It got set last month.
Should we just get a trial date out, you know, maybe 2 months?
No. I mean, let's just make sure the stuff gets done. Because when you set stuff out that far, they tend to not look at it because they're just so busy. It's better to just keep little settings so we know that we can get on
Did I
top
do
and
like
stay
a
on top of.
2 week reset and then we'll?
Yeah, you want to eval it too?
Yes, sir.
Yeah, set it 2 weeks, eval it,
Okay.
and then if it's good for you, start putting the video in to get transcribed. Because he says he's going to trial unless you dismiss it. So, yeah, okay, all right. Bershams. Hi.
Need to get more Arabic speaking cases. Sorry.
That would be an interesting case. Yeah. Anyways,
All right, Your Honor, I got Mr. Kabir, who's in the boxes for BVR. I have a feeling you're gonna wanna raise bond or do something, so
come on, Mr. Kabir.
if you were leaning towards that, I would like to request a hearing and have a record on it.
Sure.
But that's only if you wanna raise. I hope you don't.
I mean, he tested positive. I've asked him not to use. I've asked him not to consume anything illegal. I've asked him not to consume alcohol. He's still using.
Your Honor, it was, I spoke with pretrial, if, just hear me out for a second.
Sure.
Spoke with pretrial, it's a presumptive lead for THC. Things like Delta 8, kratom, hemp, those are all legal.
I admonish him over and over. This is our third bond violation. If I let him go, I'm enabling the behavior and I'm saying that it's okay to happen. It's a third bond violation, Mr. Kabir. I'm setting you for a hearing in 3 days. You must be here, be ready to go forward. Do you understand? I can't continue. It's a third bond violation. It's unacceptable.
Understand. And look, I appreciate you giving us a little time for the hearing. I was here yesterday as well. We are looking like, it looks like we're about ready to set this for trial anyway. Do you want to wait till the hearing?
If you want to set it, you can, but I'm requiring his presence in 3 days here to have the BVR hearing.
You said 3 days or 3
3
weeks?
days. No, 3 days.
3 days.
So that you can get all your ducks in a row, get all the evidence you need. State, get ready, please, as well.
Yes, Judge.
But, if it was a first, we admonish. Second, sometimes, okay, we're now at a third time.
Yep.
No. Yeah, okay, I'll see you in 3 days. If you ever miss again, I will issue a warrant for your arrest. There's absolutely no tolerance in the future. Do you understand?
Yes, sir.
Court orders are court orders and you don't just evade and decide to do what you want to do. Do you understand? You were ordered to go take a test and you failed to go take a test. That's the rub. I'm sending you now for a test.
Sorry, so he has ordered to go get a drug screening test and he did that. They have the results back.
When did you go take the test?
On 16.
Judge Fleischer said it came back positive for THC. Confirmed by the lab.
Oh, I see. Okay. No more using. Do you understand? I'm going to test you 50 days from today. If you test again, I'm going to put you in custody.
Yes, sir.
You understand?
Yes, sir.
Okay. All right. So got you guys. We'll set you off for.
This is a huge turning point. When the judge mentions clinicians and evaluations, he's basically saying, my hands are tied. The experts think she's high risk, and I'm not gambling again. Judges often track defendants' histories, and when someone repeatedly hits extreme BAC levels, it destroys trust. Quick question for you. Should a parent's responsibilities outweigh rehab recommendations, or is safety the priority?
50 days.
So Judge, at present, Mr. Jones has both a scram device on and a GPS, and he's on a curfew. He's broken curfew a few times, Judge. If you look at the times, though, it's because he's leaving a little early and getting home a little late, the latest maybe being half an hour past curfew. Mr. Jones has maintained gainful employment. He's worked as a helper for a transport company. He's not driving, he's the helper. And so he gets on the truck with the driver, he helps, and then they get back to their site. His wife picks him up from work, and then they pick up their grandkids, and then they get home. He's driving from the east side of town, across the ship channel, down 610 West, and then all the way to 90 into Crosby. It's a long commute. And so due to all that, and his employment is working with him right now. So they typically wouldn't be done at the times they're done, but they're to keep him on. They're trying to make sure he's done by a certain time so he can make curfew, but it's just a tough commute, especially when he's not the one driving and they have to pick up children because there's only one person that can drive. But he is only late and he only leaves early because of work. That is the only.
You have to understand, you have 2 open DWIs, so it's absolute strict compliance. I never want to ding anyone for working, right? I want you to work because I think that, you need to work. Number one, you need to make money and it gives you something to do so you don't become more self-destructive as it is. I see the violations here. We have no alcohol violations, correct? Okay, that's good.
Joshua or?
Joshua Jones. Do we have any alcohol violations?
I have no problems now, Judge. Trust me.
I don't see any previous violations, Judge.
Okay, so it looks like most of the stuff, I would tend to agree with you that, upon further inspection, it looks like it may be a little bit here, but there, but prior to. Is all this work related?
So
Okay, so what time do you leave for work in the morning?
I normally have to be to work at 7,
Okay,
most times.
because I have here that you leave one time here at 5:56 in the morning. So why that early?
Like I say, most times it's anything that I'm leaving is work related. And one of the things that I've been trying to do since I got out was maybe to get in contact with my lawyer to kind of help me out.
But you're not getting in touch with your lawyer at 5:56 in the morning?
So just because it's a transport company, those jobs have different timelines. They are aware of the circumstances, so they try to tighten up on those timelines. But if they have a job and might need him one day at 6:30 or something like that, that's when he'll have to leave early. And he's afraid he's going to lose that job if he can't comply with what they're asking of him. So I'm asking today, Judge, if we can loosen the timeline a
I'm
little
okay
bit.
with tweaking the schedule.
Okay.
But I want to do it in a real, I'm not going to give you too much leeway. We have to be reasonable about it, right? So I need a time that that's early enough that, you're not going to violate anymore because I don't want to continue to do this, right? So what is a reasonable time in the morning for you to leave?
If he would have asked me to get to work between 6 and 6:30.
How far is it from home to work?
It's maybe a good hour, 10 minutes if it's bad traffic or weather.
What about coming back home? What's a reasonable time?
It's not.
I'm not going to do 9 o'clock. I'm not going to do 9. I don't want you out that late. I will give you a little bit of time after 7 o'clock, but 9 o'clock is too late. When you're coming home here now, you're coming home at the latest at around 7:30. I'm willing to give you, 7:45, 8 o'clock, but that's the latest I'm going to give you.
8 o'clock is fine.
Okay, so Jillian, we'll tweak it 5 in the morning to 8 at night. If there are any more issues, I'm going to lock you up. I'm working with you now. There should be no more issues. I want you to work. I just don't want you drinking, and I don't want you out in the middle of the night because nothing good happens out in the middle of the night. And I definitely don't want you driving. Do not drive. I don't care what circumstance comes in your life. Do you understand? I'm really going to hit the roof if you drive. Okay. All right, Jillian.
Thank you, Judge.
You got it. Good morning, Ms.